Well, when ATMs started spitting out thousands of dollars this week, many thought Christmas had come early. Police were quick to remind us that this was definitely not a case of finders keepers, and at least one man now faces charges. So when fate lands your windfall, what can you do to hold on to it? When can you hold on to it? Lawyer Sam Macedone joins us now. Good morning to you, Sam.
Good morning, Karl.
So in regards to money through ATMs and on the street, what are the rules?
Well, basically, if you find some money, for instance, when you're walking down the street, say it's $50, if at the time you find it, you believe that if you make some inquiries you can find who the owner is, then you can't keep it. If, however, you reasonably come to the conclusion that you just can't find the owner, then you're quite entitled to keep it. For instance, you're down the street, $50 comes floating towards you, you look around and there's absolutely no one around, quite obviously you can't work out who owns it so you can keep it. But if I see you running down the street waving your hand saying my $50, I can't put it in my pocket and keep it.
What about, there was a guy last year who lived in Sydney, was on a train, I think it was $50,000 in a little bag or an esky or something. You have to report that?
Well, yes, because if he were to keep something like that, it's quite obvious, or it should be obvious to him, that if he were to make some inquiries, there is a possibility that the owner of the money would be found.
Right.
And by simply handing it in, the police would then sooner or later find out if someone owned it. If not, it would be returned to him.
Right, it's good, isn't it? What about, we talked about last year and towards the end of last year, having put furniture out on our curb and also white goods, and they were pilfered, I reckon, within about 12 hours. What are the rules in regards to driving past someone's house and picking up furniture or white goods or whatever the case may be?
Well, if you drive past during a council clean-up time and people are putting stuff out on the footpath, obviously that is being stuff that's abandoned and you're entitled to pick it up. The owner obviously no longer wants it. He puts it out there for the council to pick up and take to the tip. So if you want it, you can have it. And obviously it's not stealing. I thought of an interesting situation where you pick up, for instance, a chest of old drawers, and when you're putting it into your car, you're pulling it apart because you're going to restore it. What happens if you find $100 in an envelope taped to the bottom of the drawer? Can you turn around and say, well, it's abandoned, I'll take the drawer and the money? But really you can't, because it's quite obvious that if you were to make some inquiries, in other words, knock on the door where the furniture is in front of, you'd probably find the owner. So whilst you can keep the chest of drawers, you'd have to give back the money.
We had a few emails, amusingly, last year when someone said they were mowing their lawn, they were during council clean-up, they went inside to get a drink of water and they came out and the lawnmower had been, had been pilfered. That's obviously against the law.
Well, it is, especially if the lawnmower was going at the time.
It was. It definitely was doing that. What about house squatting? What are the rules with squatting? It's a long tradition in this country, isn't it?
It is a long tradition, and look, it's a pretty complex area of the law, but if I could generalise it this way. In New South Wales, most title is held under what's called Torrens title. That title is indefeasible at law, so it doesn't matter who squats on your land. For instance, if you're the registered proprietor of your house that's registered under Torrens title, no one can take it from you, ever. If, however, it's Crown land, that's not a park or a road or something set aside for by way of a Crown grant, you can actually squat on it. That means taking adverse possession of it, and if you do that currently for 30 years, you can make application to own that land.
Really?
Prior to 1970, you had to be sitting on it for 60 years, but now currently it's 30 years. That's Crown land. If it's private land, in other words, not Torrens title and, for instance, old system title, you can squat on that adversely to the interests of the owner for 12 years since 1970, and then you can make application to obtain possessory title to that land.
Right.
Before 1970, you had to be on it for 20 years.
Very interesting stuff, Sam. Good to talk to you. Thank you for your expertise.
Pleasure.
All right.
Thank you.